In this final lesson, exploring specifically the Norman conquests and the impact that this had on the early English legal system, we'll explore probably the most important aspect of this early period. This is, of course, in the development of feudalism. So, from a sort of general European perspective, feudalism is a system that emerged in Europe after the fall of the Western Roman Empire. Of course, the Roman Empire then moves to Constantinople and is then transformed into what we sometimes describe as Byzantium today, or the Byzantine Empire. But within Europe, feudalism plays a pivotal role when we think about the structure of medieval society. In England specifically, feudalism is solidified and redefined following the Norman conquests, and has an impact on the nature of land law, of land ownership, and of legal rights. So that's what we're going to explore in this lesson, the development of land law and feudalism during the early period of the Norman conquests under William the Conqueror. So after William the Conqueror's victory at the Battle of Hastings that we spoke about previously in 1066, one of his most important tasks was to try and consolidate power across England. He still hadn't consolidated power completely across England. We as historians tend to think of the Battle of Hastings as the point at which William the Conqueror takes over, but there's still quite a lot of work to be done in terms of consolidating authority across the entirety of the realm. The same can be said in 1485, when you think about the Battle of Bosworth Field, with Henry VII defeating William III. That's all well and good, but that's the sort of period that marks, or at least the date that marks the initial period of the Tudor dynasty. But there's a lot of consolidation that takes place afterwards. You have a lot of pretenders, you have the Battle of Stokesfield as well, you have Perkin Warbeck, you have Lambert Simnel, all of these different people who try and consolidate power and try and continue the Wars of the Roses. That's what happens in context with the Tudor period. But in terms of for the post-Norman conquest, the consolidation of power across England is an important thing that needs to be achieved. Feudalism then was one such means of organising and managing the land and the people of the kingdom, and securing loyalty and military service from the crown. There are a few fundamental bases of feudalism. So first is this idea that land is the basis of power. In a feudal society, land becomes the primary source of wealth. The king, as the ultimate sovereign, theoretically owns all of the land in England. By conquering that land, he owns it all. He then grants large portions of this land over to his most trusted followers, normally Norman nobles, knights, and supporters, and this is in exchange for loyalty and military service, as well as other duties. A second feature of feudal structures is the idea of vassalage. In a feudal system, the king's most powerful subjects, the barons, the earls, and the lords, become what are known as vassals. The vassal then pledges allegiance to the king in return for the granting of control over land. That control over land is known as a fief. Vassals could then in turn grant portions of their fiefs to their own subordinates, and those subordinates become what is known as subvassals. This relationship between lord and vassal is formalized by an exchange of land for loyalty and military service. This all together then creates a structure of feudal hierarchy. The structure is very hierarchical. If you've got the king at the top, the king granting land to his most loyal supporters, those loyal supporters granting land to their most loyal supporters, and so on and so forth. The king was followed by his barons and earls who held large estates. Below them were knights and lesser lords who had smaller parcels of land but were still required to serve their lords militarily. And at the bottom of the hierarchy you might have peasants or serfs who worked the land and had very few rights. Ultimately then, the feudal contract governed the relationship between landowners and their vassals, and this contract was largely based on obligations and reciprocal duties. What emerges then in the feudal society is the idea of land tenure, and that's because in feudal society, land was not considered an absolute private property of the holder in a modern sense. Rather, land was held in exchange for service or for payment, and its ownership was seen as conditional on the performance of those duties. Several forms of land tenure then would develop in medieval England, and they would form the most foundational backbone of the land law system during this period. So you have, for example, the feudal tenure, the knight's service. This was the most common form of land tenure in the early feudal England period. Under this system, a lord would grant land to a vassal, usually a knight, in exchange for military service. The land was granted to the vassal on the condition, essentially, that they would provide the lord with a specified number of knights or soldiers where and when military campaigns would need to be fought. This is often in the form of something known as subinfeudation. This is where the vassal could further grant portions of their land to sub-vassals. We spoke about subinfeudation in a previous lesson on the subject of land law, but that's the kind of way in which we get the hierarchical structure through the feudal tenure and then through the process of subinfeudation. Bookland or bockland or charterland were often forms of land tenure based on a written document or a book, meaning deed. This is what granted the land, and it was where essentially the tenant held this land on condition of certain obligations. But it was not as temporary as land that was held through military service. So bookland grants often had fewer service obligations and would often tend to last longer, and in some cases were even inheritable. And so this essentially formed the precursor to the idea of the freehold tenure, where tenants held land as a form of private property. You then also have the socage, which was another form of land tenure. Unlike the knight's service, which was tied to military service, a socage tenant were required to provide other services or rents, such as, for example, farming the land or paying a certain sum of money to the lord. And so this became the most common form of land holding for free men after the reign of Henry II, which we'll get to later on. But this becomes the precursor to the modern concept of land ownership. You then have something known as the Frankelmoin, if I'm pronouncing that correctly, a form of tenure held by religious institutions, such as monasteries and churches. The land that was held under a Frankelmoin was not subject to military service, it was not subject to rent, but it was instead held in return for prayers and religious services. So this tenure allowed the church to essentially build wealth and power, and the benefits that were offered in return were simply spiritual benefits. And this is one of the reasons why the church becomes so powerful, because they're essentially given a higher than ordinary playing field, because they don't actually have to hand over any physical wealth, they just have to hand over spiritual benefits, which was obviously beneficial for them. Finally, then, you have something known as the serjeanty. This is a tenure in which the tenant held the land in return for a specific non-military service, such as acting as a royal messenger, or even maybe providing things like horses for the king. It was a very rare and often very specialised form of tenure, and so isn't often cited or mentioned at many points when thinking about the history of land law. So, one of the key features of this feudal land system was this idea that land was held from a superior, usually the king, at least at the very top, and the relationship between the landowner and the king was governed by contractual obligations. And so from this, we get a few conclusions. Firstly, the first conclusion is the one that we spoke about at the beginning, is that this idea that all land is held from the king. Or held by the king specifically, even though individual landowners, such as barons and earls and knights, did have legal rights, and they had legal rights specifically to the land that they controlled, they were not freeholders in the modern sense. This is where we get the idea of the freehold estate from, by the way. You are a freeholder of that land. In the eyes of the law, all land was ultimately owned by the king, as it still is to this day, and a landowner's right to the land was conditional upon their loyalty to the crown and the fulfillment of obligations of military service. Feudal land would often then be passed down through different generations. This is through the idea of the idea of inheritance. However, the ability to inherit land was governed by strict rules. These were strict rules of primogeniture, the idea of the eldest son being able to inherit the estate, as well as the rules of escheat. Again, pronouncing these probably incorrectly, but this was the principle that the reversion of land to the crown would take place if a tenant died without heirs or if the landowner themselves were guilty of treason. When a vassal would die, his heir was required to pay a fee to the lord to inherit the land. This payment became known as the payment of relief, and it was considered a sort of form of acknowledgement of the fact that the lord had a certain sense of superior authority over that of the vassal. As we've mentioned as well, the idea of subinfeudation was something that essentially takes the concept of the very basic principle that the king owns all of the land to the concept of the hierarchical structure of land law and feudalism that we start to see. So the practice of subinfeudation allowed a tenant to sublet their land to others. Essentially, a tenant could grant part of their land to a sub-vassal while remaining liable to the superior lord. And so this leads to a very complex set of hierarchies and landowners with multiple layers of vassals between the crown and the peasantry. So you've got the crown on the very top, you have the peasantry at the very bottom, and in between that you could have many, many, many different layers in which we see this practice of subinfeudation take place. So as this feudal system would begin to evolve then, there was a need for a more structured legal system to essentially catch up with it in order to resolve any kind of disputes that would arise over land. So firstly, we see that there were writs, formal written orders that were issued by the king's courts to address specific issues, such as land ownerships or challenges to ownerships. And you also see the introduction of writs leading to the creation of the Court of Common Pleas, which dealt with property disputes and laid the groundwork for this common law system that we'll get to. Now, skipping ahead quite a far amount, in fact, I'm just going to very quickly expand a little bit on the decline of the feudal system. So we'll talk very briefly about this in the sort of modern land law period, but ultimately there are a number of factors that contribute to the decline of feudalism. One such example is the Black Death. This was the plague of the 14th century that decimated the population of Europe, killed about a third of the population of Europe, and it led to a shortage of labour and a breakdown of the feudal structure. Suddenly, those serfs and peasants who survived the Black Death realized that their labour was far, far, far more valuable now because there's far less labour supply, so the demand for them was increased, basic economics. And so they were able to demand higher wages and even purchase their freedom, which weakened this system of land holding based on serf labour. We start to see, as trade and commerce flourishing, the importance of land as a sole source of wealth begins to diminish. So a growing merchant class, for example, begins to value money over land, and this contributes again to the weakening of the system. Furthermore, under the Tudor period, so we're really jumping ahead now, we're into 1485 to 1603, which is the Tudor period, particularly under the reign of Henry VIII, which was 1509 to 1547, there was a shift towards a more centralised monarchy. The crown began to assert more direct control over land and reduce the power of feudal lords. Famously, Henry VIII's father, Henry VII, would pass a number of things such as Acts of Attainder, bonds and recognizances, and all of these different financial constraints on the nobility to maintain a certain sense of control and dominance over them. This all came after, of course, the period of 1450 to around 1485, which was, of course, the period of the Wars of the Roses, in which you see quite a lot of conflict over who can really take the crown, and it's a very messy situation. And so Henry VII sought to stamp his authority by keeping the nobles down and suppressed. When we come to Henry VIII, then, things like the dissolution of the monasteries brought vast amounts of church lands into royal control, and again upset the very delicate balance of feudalism that is beginning to crumble and collapse during this period. And then finally, as the feudal system breaks down, the notion of the freehold land that is held absolutely without service or obligations, begins to take hold. And so in the sort of 16th and 17th century, we see the end of the feudal system and the development of modern land law as we know it today. We will get to all of these things in future videos' time as we continue thinking about the English legal system, but for now let's just conclude by thinking that the idea of feudalism was one of the most important aspects, one of the most important introductions to the English legal system that was contributed by the Norman conquest and the conquest of England. The next lesson is going to focus, the next topic, should I say, the next series of lessons is going to focus specifically on the reign of Henry II, who reigned from 1154 to 1189, because this was the period where we see the birth of the English common law. So what a very important period of history. It is then at that point that we start to think about other major developments such as Magna Carta of 1215, and then we will move into the 13th and 15th centuries, we'll move into the 16th and 17th centuries, and then finish by looking at the 18th to the 21st century in terms of our history of English law.